Okay, thank you everyone for those who are joining us today. So as you are all aware, this is the African International Mediation Week 2020. Today is the 1st of December 2020, and it's now 11:30 a.m. East African time here in Nairobi. So I'd first and foremost like to welcome you all to this session. Thank you for making time to join us today and to engage with this particular forum for the day. So our speaker for this session will be Mr. William Yagan. He is from the Faculty of Law, Catholic University of Eastern Africa, Kwea. He's a certified mediator and an advocate at AganI Associates. So he will be our facilitator for the day. And our topic for discussion during this period will be do it yourself with model contract clauses, IP protection mediation clauses for contracts for the supply of creative services. So that is what we'll be engaging with. And before we start, we will begin with the national anthem, and then I will be able to invite our speaker for the day. So I will just recite the words of our national anthem in Kiswahili for us to begin the session. E Mungu nguvu yetu, ilete baraka kwetu, haki iwe ngao na mlinzi, na tukae na undugu, amani na uhuru, raha tupate na ustawi. So thank you very much. Before we commence, just some housekeeping. Please ensure that your microphone is mute during the session. And yes, please just ensure your microphone is mute. And if you need to engage, you can engage to the chat facilities. So at this juncture, I'd like to invite Mr. William Yagan to take us through the session. Thank you.
Thank you very much, Amanda. Thank you very much, Wangari. It's always a pleasure to be here and to share some of the secrets that we need to share with colleagues. Today I will be having a very short presentation, and just allow me to share my screen in a moment. Listeners, viewers, our discussion today will be a mixture of what we in the academia need to do in our university curriculum to position ourselves for what is going on globally, and to also look at, in particular, do-it-yourself mediation clauses, and thereafter we will conclude. It is known, and perhaps those of you that may have had a chance at academia know that there's a lot of bureaucracy, especially in our universities, perhaps private universities not so much, but public universities, when it comes to curriculum revision, usually done after every 5 years. I am aware in the faculty, we have just done a revision, meaning that we have about 4 years to once again revisit that curriculum. And that may not sound very well whenever there are new events and changes in the subjects that we do. So what then do we do? It's important that as individual course instructors, we take the responsibility of tweaking the course outline, because the course outline is an instructor's responsibility. It would be foolhardy to wait, and especially in this particular area that we will be looking at today, ADR and arbitration, which in the old curriculum, or I can actually say in the current curriculum, mediation is still relegated to a corner, and arbitration seems to be the one that is reigning supreme. But there are new changes, there are new developments that cannot wait. This bureaucratic approach of revision of curriculum, and as such, it only makes sense that given what is going on right now, we cannot wait, because mediation today has actually joined the list of dispute resolution mechanisms like litigation and arbitration. You do realize that if we are not careful, it would be very possible for us to make the mistake of treating mediation as we have always done, and that is that it is an alternative. Now it is no longer an alternative. It has joined the other brothers, litigation and arbitration, and yet with better features and better advantages. And as such, it's important that the various institutions, various associations that are directly or indirectly involved in mediation training do adjust, amend their curricula accordingly. Now we have good news, and in fact, if you are in the first session, the good news to all the international commercial contracts or parties to international commercial contracts. This is good news because it is possible for the same to now be settled because we now have the United Nations Convention on International Settlement Agreements resulting from mediation, otherwise also known as the Singapore Convention. And this, of course, applies to international settlement agreements resulting from mediation that have been concluded by parties to resolve a commercial dispute. What does this then mean is that it's important and paramount that contracts entered into, and in particular, where the parties fit the character of international, add a clause and or a whole agreement which provide for mediation as settlement, as a settlement option, as long as parties have the same in their minds. They need to agree, they need to consent to such an agreement. Now, model clauses or agreements have very many advantages, and there are so many principles that make them very admirable. And one of the principles is party autonomy. Party autonomy simply means that the parties are free to agree on the manner in which they would want their dispute, should it arise, mediated. So clauses usually would be a one-size-fits-all as long as they reflect those principles. We've seen this in the International Bar Association for arbitration model clauses, and today what used to be part of a tiered or escalation or multi-step arbitration clause with a first shot at negotiation and then followed by mediation, then ending with arbitration, no longer takes place of the third fiddle. So mediation no longer takes part of the third fiddle. Of course, unless parties consent to doing so, again, taking advantage of the flexibility of mediation. So in as much as mediation has joined the big brothers, in as much as it is now, and we have seen, as far as an international commercial agreement is concerned, it has actually joined the other brother, arbitration, as a dispute resolution option. It still retains its flexibility, meaning that should parties choose, then it can still operate with the then big brothers arbitration and litigation. Now, example of a model mediation clause, and this one I borrowed from the Stockholm Institute, which really is a very general mediation clause that can be thrown into any contract. Says any dispute, controversy, or claim arising out of or in connection with this contract, or the breach, termination, or invalidity thereof, shall be referred to mediation in accordance with the mediation rules. Of course, now the parties, where there is an institute, the parties can actually refer to the rules of a preferred institute. Again, we shall be looking at core elements in a moment, which, just like arbitration, make it possible for the parties to be as detailed as possible. And that is the reason why I usually go beyond just indicating that a clause be thrown in as part of the contract, because then looking at the core elements that we will be looking at, which of course are familiar to most of us, you realize that such a clause can be a very lengthy one. And as such, there is no harm in actually having a mediation agreement. Again, do not mistake this for an agreement to mediate. It's very much part of the contract where parties agree that should there be a dispute, then they would mediate, and it's just bigger than a clause that just forms a paragraph or so. Now, being facilitative and having certain services like the creative industry, which may not have many mediators or judges who fully comprehend the complexities of the industry, mediation would be most suitable, simply because the parties would usually agree on how to go about resolving their differences, with a mediator facilitating such a process. Again, this is a great advantage that mediation has, because the mediation does not come and use any authority to impose on the parties how the parties should go about resolving their dispute. Rather, the parties, knowing their industry very well, and believe you me, the creative industry has some of the most complicated contracts. So this really is the best way to go, as long as a clause or an agreement is added to any of the contracts that are those that can be mediated and those that are, of course, arbitrable. Again, it's not all disputes in the service industry that can be referred to mediation. Now, again, for us, we have WIPO, Arbitration and Mediation Center, that, of course, is World Intellectual Property Organization, which specializes in matters intellectual property. So WIPO facilitates the resolution of commercial disputes between private parties involving intellectual property through procedures other than court litigation, including mediation and arbitration. And of course, you know, the topic here is on the creative industry. And those of us that have had a chance of going to court with intellectual property as a subject matter have really, and will agree, and this is in, you know, with all due respect, that the judicial system is not very friendly to these types of subject matters. Again, it is not all, in fact, most judicial officers are not experts in matters intellectual property, and as such, it becomes very frustrating, very frustrating for litigants. And as such, the best advice is for them to forget about taking these matters to court altogether and get the benefit of an institution or a mediator who is an expert in matters intellectual property. Now, do we reinvent the wheel? Again, if you're in the creative, you will actually say no. That's actually about the creative industry. We do not reinvent the wheel. The wheel has already been reinvented when it comes to matters having, you know, model clauses. So we don't have to reinvent the wheel because there is so much already around us that we can borrow. We can borrow from well-laid principles of flexibility, party autonomy, among others, to come up with beautiful models, either for ad hoc mediation or institutional mediation. All we need to have in mind are just the core elements, which we shall just go through as a list. We have, you know, the place of mediation, meaning that it's important to have in mind and agree where we intend to have mediation should there be a dispute, where the parties want the mediation to take place, language of the mediation, you know, this can be any language that suits the parties, duration of mediation proceedings, you know, again, you know, leveraging on party autonomy, you know, it's all that you will agree on that will be followed by the mediator. and setting a timeline for mediation, which helps the case stay on track towards a settlement or agreed follow-up procedure. Now, this is a sample mediation clause, again from WIPO, that can be used. It is free for all, size fit all, for the creative industry. And in a moment, we shall also conclude by looking at the scope of WIPO when it comes to what WIPO engages in the creative industry. So any dispute, controversy, or claim arising under, out of, or relating to this contract, and any subsequent amendments of this contract, including, without limitation, its formation, validity, binding effect, interpretation, performance, breach or termination, as well as non-contractual claims, shall be submitted to mediation in accordance with, in this case, the WIPO mediation rules. The place of mediation shall be, as we had indicated, in the core elements. So you can specify, and you can also specify the language. Okay, you can specify the language. Now, looking at this, you realize that the core elements have been very cleverly placed in this particular model clause. So what is the scope of IP and commercial contracts that can benefit from the WIPO model clause? Licensing agreements, example, trademarks, patents, copyright, and software. Of course, this is very common. You do realize that an owner of any one of these can only commercialize by licensing, if not assignment altogether. And then the R&D departments that bring in researchers. Then we have technology transfer agreements. This is a big deal, both on a small scale between companies and individual parties, and even between states. Is a really, really big deal. Distribution agreements and franchising agreements, again, this is an area that we are all aware tends to have quite a number of disputes that arise from disagreements. Then information technology IT agreements. We have data processing agreements, joint venture agreements, consultancy agreements, marketing agreements, TV distribution and formats, film production, copyright. I think this one should make some of you jump from your seats, because you know this is, especially here in Kenya, you know, we've had a very nasty experience where members of various collective management organizations, CMOs, are accused of not complying with the law. And since it's public knowledge, you do realize that we've had MCSK being dragged to court for non-compliance to the Copyright Act, where it had not filed its returns for several years, and as such had to have its license revoked for a while. And you can imagine, instead of going for mediation, the parties went to court. So you can only imagine that we would not be discussing this because no one would have known had the parties resorted to mediation, given the confidentiality nature of mediation. Then, of course, settlement agreements of prior court litigation. So what then is the conclusion for the creative industry and the parties in that industry? Make sure that you always have a clause, a mediation clause in your contract, as long as the scope covers the list that we have just gone through. Is it complicated? No, it's not complicated at all. And perhaps it's as easy as ABC. Thank you very much.
Okay, thank you very much, Mr. William Agan. Our speaker of the day has been Mr. William Agan, and he's been giving us an insight into the creative sector and mediation agreements, such as intellectual property and a number of the aspects he's been talking about as well. So I think I'd first of all like to appreciate our speaker, Mr. Agan, for making the time to really share these insights with those who have been able to join in. I'd also like to appreciate the participants for joining in and taking a minute of their time to be able to learn a little bit about IP and learn about mediation clauses. And with that respect, I'd like to appreciate everyone who has come in, and hopefully we can join in and interact with our speaker for future sessions. So at this point, I would just like to close the session, and we will close with the words of our national anthem. So I will just go ahead and recite them, and then we can close. E Mungu nguvu yetu, ilete baraka kwetu, haki iwe ngao na mlinzi, na tukae na undugu, amani na uhuru, raha tupate na ustawi. Thank you everyone for joining in. Thank you, Mr. Agan, for making the time, and hopefully we'll be able to engage in future. Thank you.
Yeah, always a pleasure. Thank you.